Good morning, and thank you very much for joining us this morning. Allow me to start by thanking very much Lear in the person of Paolo Bussirossi for this very kind invitation. It is a pleasure to be with you today. We will be talking about the latest competition and policy, law and policy developments regarding digital markets, hearing from three key competition authorities of developing countries, but really very, very internationally and very well-established jurisdictions. I would like just to start with a very brief introduction of not so much who I am, but what is UNCTAD, because the United Nations system is so broad that I'm sure most of you have never heard about us and are wondering how come I am here with representatives from India, South Africa, and Brazil. So very briefly, and I will go very quickly, just to tell you that the organization I represent is the United Nations Conference for Trade and Development, which again, not obviously linked to competition law and policy, but we have the privilege of being the guardians of the only internationally agreed instrument, even though a soft law instrument, which is called the United Nations Set of Principles and Rules on Competition, which was adopted by consensus by a resolution of the United Nations General Assembly in 5 December 1980. So, as you can imagine, we are about to celebrate 42 years of life of the UNCTAD, as it is called. What is interesting is that, of course, even though the language is rather along the lines of what you could expect from an international public law instrument, it recognizes competition law and policy as an important instrument to promote economic growth and sustainable development. And it encompasses what we call a development dimension, acknowledging that developing countries should be allowed to adopt competition law and policy according to their specific circumstances, which in some cases has led, for instance, for competition law of developing countries, including exceptional public interest clauses. Of course, this should be temporary, as limited as possible, etc. But somehow, due to the discussions of UNCTAD, and let me briefly just show you what we do, our three areas of work. One of the most important pillars of work is consensus building. So we hold intergovernmental group of experts meetings every year, and it's a little bit through these meetings what is discussed and agreed, and sometimes the choice of topics that also drive our research and analysis and our technical cooperation. So I would say that thanks to UNCTAD, but of course also to the very important work of the friends from OECD, from the World Bank, from, let me add, the European Bank for Reconstruction and Development also, and the European Union and several other regional organizations, that we have moved from a situation in the 90s where only 25 countries had competition law and policy to a picture of today where over 140 countries across the world have adopted competition law and policy and have set up institutions to enforce it. Just very briefly, because UNCTAD has a mandate devoted to serve developing countries, to show you a little bit the extension of our technical cooperation. Of course, our 195 member states include all developed countries, and it's also through the dissemination of best practices, very much with their support and their active contribution, that we have been able to assist developing countries and least developed countries to fully implement, to do competition advocacy, so to improve enforcement, to work with sector-specific regulators, to train the judiciary, to inform consumer associations and media, etc., etc. I'm about to end. I just wanted to draw your attention to our voluntary peer reviews of competition law and policy, which are very interesting instruments because they allow a country that has some experience but has identified room for improvement, to actually submit its legal and institutional framework and its enforcement practice to the assessment of an independent expert, but interacting with more advanced competition authorities representatives, usually from the region or which have special connections with this country. And we have these discussions every year in Geneva. You will see in the screen the latest one. This year we did the peer review of Bangladesh, which is a least developed country, as last year we did Malawi, also a least developed country. And it's very encouraging to see that least developed countries have also fully understood that competition law and policy can support their macroeconomic and sustainable development strategies. So because the topic is on digital economy, I just leave here a few references of our latest research. Let me just end saying that this year we have drafted at the request of member states recommended best practices for digital platforms in order to promote a fairer and more transparent access of small and medium-sized companies in developing countries. We will be again promoting this proposal, and we hope that you will be interested to join us and comment on this. And on this note, I am done, and I would like very much to introduce the panel. I will start with Mr. Hardin Rajisusu, who is a commissioner from the Competition Commission of South Africa. Then on my right, Ms. Sanjita Verma, also a commissioner of the Competition Commission of India. And to my left, Mr. Victor Oliveira Fernandes, a commissioner from the Administrative Council for Economic Defense, better known as CAGI, from Brazil. So these are three very qualified and experienced colleagues, representatives of extremely active and well-established competition authorities from developing countries. And I would like to start with Hardin. Please tell us about the latest developments of South Africa. You have the floor.
Thank you, Teresa, and thanks to Lear for the invitation, and of course to UNCTAD broadly. I will be sharing with you today some developments in South Africa, and also looking at the broader African integration agenda within the Africa Free Trade Area continental framework. So I will be as brief as I can, and what we have done in South Africa, and we, after learning and listening a lot to a lot of developments, globally, there have been a lot of reports on digital markets, how we ought to be responding. We published our own strategy in September 2020, and that strategy was to make sure that we at least understand the implications of digital markets in the context of a developing economy like South Africa, especially as we face these very large players in a number of these key markets. We then decided that we'll pursue various tools. So it will be tools of advocacy. We'll consider enforcement in some areas. We'll consider market inquiries, and we'll sharpen our major enforcement tool to catch what has been discussed in this conference as killer acquisitions. And I'm happy to share with you that since that strategy in 2020, in May 21, we launched a market inquiry into online intermediation platforms. So this is us looking into areas such as property classifieds, food delivery, travel and accommodation, e-commerce, and online classifieds. So that inquiry is also looking at the participation of SMEs and firms owned by historically disadvantaged individuals to participate in these markets. These are quite concentrated market, and we have issued a preliminary report with various recommendations to address competition concerns that seemingly are not unique to South Africa. Similar issues have been identified in other jurisdictions as well as by international organizations, specifically UNCTAD, OECD, and ICN. So I will not go specific to that. And the second area was through enforcement. We have an interesting case now before the Competition Tribunal, which involves Meta. Here, we had a complainant who was concerned about access to the WhatsApp business application programming interface, the API. This is a player that was using the account to provide services or access to government services. So it was having close to 600,000 at times WhatsApp messages using the WhatsApp business account. WhatsApp was concerned with that and said that violates the terms and conditions of access of the business account. That is a case now that is before the Competition Tribunal for prosecution. Just today, we published the final guidelines to amend our major notification guidelines to catch those transactions that fall below the threshold. So though that is a voluntary process, we expect parties to inform us when there is an acquisition of a smaller player whose thresholds meet the minimum thresholds for notification, but may not, I think what I need to say, whose purchase price meets the minimum thresholds for notification. So this is something you'll see in South Africa. And lastly, and I hope I still have a bit of time, is just on the Africa free trade area. So there are now very advanced negotiations to have a competition policy protocol for the continent. And there's also serious consideration to include online platforms in that protocol along the lines of what you see in the DMA in the EU. So this is a big, big development for the continent. And we also had leading competition authorities on the continent, Egypt, Nigeria, South Africa, Kenya, and Mauritius, releasing a joint statement this year to strengthen cooperation in tackling competition issues in digital markets affecting African countries, which is a statement of intent signaling targeted focus in these markets. So these are, in brief, some of the developments from our continent. Thank you very much.
Thank you very much, Hardin. I wanted to mention this when I started because this example of the African Continental Free Trade Area is the latest, the most ambitious, of course, regional economic and political and social organization that has also identified competition law and policy as a key tool to promote the development and the growth of their member states. But a lot of regional economic organizations of developing countries, namely in the African continent, in Latin America, in Southeast Asia, have done the same. So I just wanted to flag this because several of our participants may be more familiar, of course, with the EU model that has clearly, in a way, inspired, but we have seen several nuances, and it's very interesting to see that in some cases it's just recognizing that member states should work together. In other cases, this is becoming almost an exclusive competence, like for the EU. So I just wanted to mention this before now asking Sanjita to share the Indian latest developments. You have the floor.
Thank you. Thank you, and thank you to Lear and UNCTAD for inviting the Competition Commission of India to this competition festival here in this absolutely beautiful city of Rome. Like the speaker before me, I will also be sharing some of our experiences and some of the regulatory and policy measures initiated in India with respect to digital markets. To begin with, I'd like to speak about the Competition Amendment Bill that has been introduced in Parliament recently. And this will have, many of the proposals here will have an immediate interface with digital markets. The broad thrust, of course, is to provide regulatory certainty faster market correction, and a trust-based business environment. And all of these objectives we feel are particularly important for digital markets, which are intrinsically dynamic. So to highlight a few of those proposed amendments, one of them is the introduction of a transaction value threshold. So this will bring into the ambit of the regulator those entities, those digital entities which would otherwise have escaped a merger review in terms of our existing thresholds of turnover and assets. The bill also seeks to introduce a commitment and settlement framework, which will again enable faster market correction. And it seeks to deepen and broaden the scope of inter-regulatory consultations, which we think is very important in the context of digital markets. Moving to the enforcement experience, like elsewhere, India also, we have seen a steady rise in the cases involving digital markets. We are looking at a wide variety of cases in the digital markets, and these are related to online platforms, online advertising, operating systems, payment systems, online retail, travel, food aggregators, etc. From a competition standpoint, these cases have involved diverse issues. We've dealt with self-preferencing, exclusive arrangements, predatory pricing, leveraging, lack of transparency, and bargaining power imbalance. Access to data and privacy are also clearly emerging as new facets of concern in some of these cases. While addressing competition issues through the enforcement route, we are very mindful that interventions in the technology markets have to be proportionate and crafted in a manner that does not stifle innovation. Coming to merger control in digital markets, it is evident from our casework that digital markets and platforms are of various kinds, and so are the nature of transactions. So wide differences. Our effort has been to understand the specific circumstances, business models, strategies, and the rationale of the transaction, and also the counterfactual. In some cases, standard metrics and theories have sufficed, while in some we have had to augment the theories of harm to reflect the ground realities. The other challenge is designing appropriate and effective remedies that eliminate the potential harm, and that is equally challenging. So behavioral remedies have been relied upon in appropriate cases. We are also relying extensively on market studies, which I think is a wonderful tool to understand the market construct and underlying competition issues. We've recently done a market study. We've done numerous, but I'd like to mention the e-commerce in India, a study on e-commerce in India, and another on cab aggregator market in India. And these two have shown that bargaining power imbalance and information asymmetry between the platforms and their business users underpin most of the competition issues in e-commerce and in digital commerce. To improve transparency of the e-commerce platforms functioning and to ensure competition on the merits, the Commission, with respect to the e-commerce study, recommended certain self-regulatory measures for the platforms, such as transparency in search ranking, transparency in user review and rating mechanisms, and transparency in the discount policy that they adopted. Similarly, self-regulatory measures were recommended for cab aggregators, and these include a transparent policy on search pricing, transparency on data collection and usage, as well as disclosure to drivers of the surge revenue shared. The advisory also advocates that no preferential treatment be given to the vehicles owned by the said cab aggregator platform. To meet the challenges posed by these very dynamic and complex digital markets, the CCI is also in the process of its own internal capacity building, and we are in the process of setting up a digital markets and data unit that will act as a specialized interdisciplinary center for expertise for digital markets. We are aware that governments and regulators across jurisdictions have proposed or advocated or are otherwise considering ex-ante measures for regulating technological markets. In fact, we have heard extensive discussion and debate on this issue over the last 2 days here at this conference. So at CCI, we are carefully following and studying such developments in the international space. Apart from proposing changes in competition law through the amendment bill, government is also taking a host of measures to address competition issues in the online space. These include proposed legislations on areas such as data privacy, internet ecosystem, and telecom. As we speak, a draft telecom bill has been put in the public domain for public consultation and comment. So before I conclude, let me say that apart from the legislative and regulatory tools, Government of India is also harnessing technology to democratize digital markets by making them more open and accessible. Government in India has created a technology stack for the entire country, which has enabled the building of various apps, and it's an open source technology stack. And entrepreneurs are building on that applications from identity to payments to other services. And that has made India a fintech pioneer in its own way. So these are extremely eventful times. A lot is happening in all our countries. A lot of policy and regulatory and technology actions are being initiated in India. And in CCI also, some key inquiries in the digital space are likely to be completed soon. So we will have a lot more to discuss as we meet again and again. Thank you.
Thank you very much. Very interesting. Of course, from these first two speakers, you already recognize that, of course, all over the world, but also in these big developing countries, enforcers are more or less all in contact and looking at each other and discussing joint initiatives to make this more effective. Last but not least, Victor Oliveira Fernandes. Victor, will you tell us about Brazil's experience, please?
Thank you. Good morning, everyone. And first, I would like to thank to Lear competition for the invitation to participate in this festival, and UNCTAD for the invitation to join the panel. I have to say that it's a pleasure to be here with Teresa Moreira and with our colleagues from India and South Africa. And I feel that it's very relevant for developed countries to discuss on this topic because we have some features that are a little bit different from what's going on in the mainstream jurisdictions. And I think that we should discuss more on that topic. And CADE, which is the Brazilian Competition Authority, is closely following these discussions on global competition in digital markets. And today I would like to share some Brazilian perspective on the challenges ahead us. And a lot is going on, of course, in Brazil as well. And I will try to cover more generally the merger review field and the field of abuse of dominance, because we have had some interesting recent developments on these both fields. And I will start with mergers. And I would like to say that in August last year, CADE has published some in-depth study on digital platforms merger reviews in Brazil. And according to this study, by 2020, CADE has reviewed around 143 cases that somehow related to digital platform markets. And 36% of these mergers involved the firms operating in online advertising markets, to 20% of the mergers involved online retailing companies, such as companies selling sports goods and optical products, cosmetics, book trade, and everyone else. As for the procedural aspects, more than 80% of these cases were examined in a fast-track basis, and in only a quarter of these cases, CADE entered in a phase 2 investigation to dig a little more into the merger. In Brazil, our notification criteria are still based on revenue thresholds, and because of that, some mergers like Facebook and WhatsApp merger were not notified in Brazil. But nevertheless, CADE has the discretionary power to request any company to notify the acquisition of potential rivals. So we feel that this legal power could be used in the digital sector as well. And second, a few words on abuse of dominance. And in last years, we handled with cases both involving GAFAN and another national dominant firms as well. In 2019, CADE ruled 3 cases against Google in the search engine market. I think the most famous one was the Google Shopping case, which was very similar to the case discussed in the European Union. And in this case, CAGI final's decision was split in half, and because of that, Google was considered not guilty, but that was a very specific situation because at the time we had only 6 commissioners at CAGI. And the 2 other cases against Google were related to content scrapping and to impediments to interoperate Google AdWords campaigns. And both cases were filed because the competition authority did not find evidence of the alleged conduct. And so in that case, CAGI did not elaborate further on the applicable theory of harm. But beyond the gap, and I think that it's very interesting to share. In last years, CAGI opened several abuse of dominance cases, investigations, concerning to high-level dominant players in Brazil in some markets. The most prominent cases comes from exclusive agreements and most favored nation clauses in online retail markets. For example, CAGI last year adopted an interim measure preventing the largest online food delivery platform in Brazil, which is called iFood, of adopting exclusivity agreements with bars and restaurants in the Brazilian biggest cities. CAGI considered that these agreements could foreclose their competition and create high barriers to entry in cities like São Paulo and Rio de Janeiro, where iFood market share was superior to 80%. And this year, CAGI has also adopted another interesting interim measure against a company called Gympass. Gympass is the largest digital platform in Brazil that brings together on one side gyms and fitness studio, and on the other side individuals and companies seeking to support fitness plans for their employees. And Gympass was clearly a first mover in Brazil, and by the time CAGI started the investigation, the company has signed exclusivity agreements with more than 2,000 gyms in Brazil. The case eventually was closed this very week, and with commitments, and CAGI has imposed restrictions on new exclusivity agreements, and it has also elaborated further one safe harbor of 20% to limit the exclusivity agreements on the platform for the future. And final words on ex-ante regulation. The debate on ex-ante regulatory measures in Brazil is still open, and we are discussing in our parliament some huge legislation for combating disinformation and the fake news problem in Brazil, which is a very serious problem these days. And in these legislations, there is some discussions about whether or not we should impose ex-ante regulations for competition in these markets, but this debate is still open and still going on at the national parliament. I think CAGI, from the CAGI perspective, we think that the enforcement of Brazilian competition law as it is today, and CAGI's initiatives on advocacy can effectively contribute to making digital markets more contestable, innovative, and opening for innovation in Brazil. And I think it's what we have to share for now. Thank you.
Thank you very much. So following the discussions internationally, but not necessarily adopting so far the same measures, I think that is also relevant. I would now like just to ask a few questions to each one of our speakers before hopefully we hear from our audience. So I will start with Hardin. You have mentioned your findings and the recommendations of the Commission on the online intermediation market inquiry. And I understand that Google platform is the key driver of online intermediation in South Africa. Could you tell us a little bit about the key recommendations in this matter? Over to you.
All right, thank you, Teresa. And indeed, I think, as I've highlighted in the provisional report of this inquiry, which we are likely to conclude this year, is that most online shopping journeys for goods and services start on general search. This is what we are picking up in South Africa. I think it applies in many jurisdictions. And in South Africa specifically, we're finding that Google search is a de facto monopoly because it accounts for over 95% of all general search across desktop and mobile devices. And in mobile, it's more than 50% of those searches. And this, in our view, has been aided by these requirements that Google search is default search tool on iOS and Android. So what we are seeing, so our main findings, which are again up for consultation by the affected parties, just specific to Google, is that, as I've said, is a de facto. We think it's a monopoly in South Africa, which means it's either we regulate or prosecute. So, but that we have not decided, which will be an outcome of this inquiry. And there's also the issues around self-preferencing. Right, and what we are picking up is that although there have been remedies in the EU to address this, these have not been very successful, at least from our assessment, which means we now have to consider whether, just like what's happening in Brazil, whether we need clear ex-ante rules, but would those be effective or not? I think it's still a challenge. It's still a big question. We're encouraged by what we see in Europe with the DMA, right? And we are drawing, a lot of lessons from that. So you will find that there could be regulations, coming out of this from South Africa, or changes in the statutes, or maybe have a special act, as we say, just to deal with this. And as I've mentioned, it also may not be enough for South Africa to only respond to this. If I look at the continent, it's a continental issue as well, to say, how do we respond as Africa? That's why what we were talking about, about a new competition policy for the continent, if that gets passed and approved by heads of state, then I think we'll see sort of meaningful and a stronger response from the continent. Authorities are joining forces. I've mentioned Nigeria, Egypt, the leading, and largest, I think, economies with Kenya and Mauritius, and others are joining forces. But it becomes a bit difficult to respond individually as national authorities to tackle this challenge. So we are doing what we can, with the available instruments, but how that will change the behavior of these large platforms, I think that remains to be seen. They could agree with what we are saying, they could oppose what we are saying, which means we might resort to prosecutions or very strict ex-ante rules. So this is our response to that. Thank you.
Thank you very much. Well, from, of course, the UN point of view, and I'm sure several of you will agree, we keep saying that global challenges need global solutions, but at least in UNCTAD, in what regards competition, law and policy, we do believe a lot in the benefits of regional solutions, so regional cooperation, whatever the lines that they follow, either within a formal regional economic organization or not. But it's true, I'm sure, that what you have heard so far already resonates with what is going on either in Italy or in the EU or in the broader Western world, so to speak. So of course you see the common issues and of course sometimes nuanced solutions through legal frameworks, regulation, or just mere enforcement. I will get to India, to Sanjita, because you talked about the bill to amend the competition law that was recently introduced. Would you say that through these amendments of the bills, you meaning the Competition Commission of India, became stronger as a regulator to effectively tackle digital markets cases?
Thank you for that question, Teresa. That is a very interesting question, because let me at the outset tell you that the amendment bill, it's a very wide-ranging in its sweep. So it has a large number of both procedural and substantive measures and amendments that are proposed. With respect to digital markets, I think I will highlight 4 key proposals which will definitely help us in better regulation of the digital space. So the first, like I mentioned when I spoke a little earlier, is the addition of the transaction value threshold as an additional criteria for notifying mergers and acquisitions to CCI for approval. This will kick in and once the bill is enacted, and the transaction value threshold as an additional criteria would be applicable if the target has significant business operations in India. So to give the context, as I had mentioned earlier, the jurisdiction at present of CCI in examining mergers and acquisitions is limited to transactions that meet the asset or turnover threshold specified in the law. But in new age markets, as we all know, there are a number of factors such as users, number of users, data, and network effects that have become means of gaining significant market position. And entities that are operating significant and successful business models in new age businesses, they command a significant valuation, even though their assets and turnover may be insignificant. So we observed a regulatory gap that these transactions were not coming for a merger review approval. So to meet this gap, this bill proposes this additional notification criteria. Now I spoke of a local nexus criteria in this, so that for the purposes of the deal value threshold will have to be laid down by the Competition Commission of India through regulation. So these would need to be linked with factors that affect valuation of an entity in new age markets, and the criteria would largely be based on market-facing factors such as number of users, number of contracts, etc., of the target that are not completely reflected in the financial statements of these entities, yes. So we will deliberate on this issue of the local nexus criteria in great detail, and only after wide-ranging public consultations with stakeholders, these regulations will be firmed up. The second issue that I would like to highlight in the context of digital markets is that the regulatory intervention needs to be swift and nimble, so the bill has proposed the introduction of a commitment and settlement framework for certain anti-competitive agreements and abuse of dominance cases. This amendment will make the law holistic, and it would provide a trust-based solution to businesses. It will be less intrusive and less prescriptive and easily adopted by entities. And it would definitely help in faster market corrections. It would obviate the need for detailed inquiry and also reduce potential litigation once a commitment settlement proposal is there. Third, the bill seeks to broaden the scope of anti-competitive agreements. So this proposal has important implications for addressing competition issues in new age markets, where there are novel business arrangements, and these are entered into in multi-sided platform ecosystems, unlike the traditional binary horizontal and vertical type of anti-competitive agreements. So the bill proposes that any party that is found to be facilitating an anti-competitive horizontal agreement under the presumptive rule, it will now come under a presumptive rule of appreciable adverse effect on competition. If enacted, this aspect will help cover hub-and-spoke cartels, where the anti-competitive agreement between players at a horizontal level is facilitated through a vertical common player. And this is an important development, we feel, considering the increase in the likelihood of such arrangements in new age business models. And finally, I will speak about the proposal in the amendment bill to broaden and deepen the scope of consultation among regulators. The digital markets have an overarching and cross-cutting role the technology markets, and they interface with different regulators. They work in different sectors, they interface with different regulators. So this is a crucial area of reform. The proposal to expand the scope of consultation will engender a committee amongst regulators, and then it would remove unnecessary gaps and overlaps between regulators. It is likely to reduce regulatory arbitrage and would result in a cohesive and holistic regulatory architecture and enforcement, providing much needed certainty also and predictability to businesses. So, in fact, the bill as it stands, the amendment bill, has also enabled the CCI to enter into memorandum of understanding with sectoral regulators. So it can institutionalize the interregulatory consultation framework. So in sum, we feel that the proposed amendments will make the law more contemporaneous. It will make it futuristic in dealing with competition issues in digital markets. Thank you.
Thank you very much. And now I turn to Victor. And I would like to ask you about the intersection between privacy and competition matters in merger control. I know it's a very broad and a very topical issue, but we know that, of course, Brazil adopted data protection law a little bit along the lines of the European regulation. I would like to know, in merger control cases, if you could tell us very briefly, how has CAGI been combining, so to speak, competition through merger control with the new privacy regime?
Thank you, Teresa. I will try to address in a few words. And that's a very hot topic in Brazil because the general data protection legislation came into force only in 2020. So we have just 2 years with this new legislation. And during this period, CAGI has tried to make some stable cooperation with the Data Protection Authority as well. In the last few years, we have had 3 cases evolving this discussion on competition and privacy regulation. And unfortunately, we did not have time to dig deeper into these cases, but from CAGI perspective, we think that we can handle with privacy concerns through the lens of quality competition. So in markets where the merger or the concentration or the transaction raises problems on competition and in the quality dimension, some concernings around privacy can come into play. And in a very briefly words, and we just assessed one case involving the 2 largest retailers, online retailers in Brazil, and actually in this merger, the second largest online retailer in Brazil has bought some fintech, some payment solution, some very small payment solution firm, but this small payment solution firm in the past has celebrated an agreement with the first online largest retailer in Brazil, which was a face-to-face competitor to the second one, and it was raised some concerns on the transfer of sensible data between competitors through this acquired company. But CAGI has stated that the concerns around consent and violation of data protection legislation fall out the scope of the competition analysis, but we look at these markets through the lens of competition for quality and for service when it is valuable for consumers. So I think that it's in very broad terms what we think.
Thank you very much. The experience is still unfolding, so to speak. Well, I think we have heard very interesting latest developments, both on legal point of view, on enforcement, on soft law, on cooperation with the sector-specific regulators. I would like now to open the floor, ask if in the audience there would be any comments or questions to our speakers. I see one over there. Could you please identify yourself and indicate if you are asking the question to a special speaker? Thank you.
Hi, I'm Maria from Commission for Competition, Serbia. I would ask the Victor about the case of platform, gym and fitness studio. How the case started? How you identified?
And that's a very good question. The case started with a complaint which was filed by the strongest rival of Pass, which is called Total Pass. So it was kind of a private litigation which afterwards come into the radar of the competition authority. But that's how the case has started.
Any other question or comment? Another one here, please.
Asser Hansen from Merger Files. So a question for Sangeeta regarding the amendment bill. Just a very practical question. So what's the time frame, and is it expected to be adopted as one comprehensive legislation or in several pieces or stages?
Okay, so the process is like this. After the introduction of this amendment bill, it has been referred to a parliamentary panel for examination and report. And the parliamentary panel has been, this is the democratic process in the country. The parliamentary panel as of now has been given 3 months. And we are hoping that the bill may be admitted and considered by Parliament in the winter session this year. But this is a process, and we will know shortly. And yes, we expect that it will be as one legislation. But like I said, that it will depend on the comments and the recommendations that emerge from the parliamentary panel also. Thank you so much.
Any other comment or question? And then Paul.
Yes, hello, this is Don Gil from MLEX. I had another question for Sangeeta, in this case on the DMA, and how, as you said, the CCI is studying some ex-ante rules that other jurisdictions have applied. So I was wondering what's exactly your opinion on DMA, and what of their provisions could be adapted, you think, to the Indian jurisdiction?
I think that's, yes, like Teresa is prompting me here, that's a tough question, but it's also premature. At the moment, you are all debating and discussing the manner of implementing and execution of these enactments, and we are very carefully studying the global developments on this issue. And we will in due course discuss and come to some thinking on that. So at the moment, we are at the stage where we are also studying how these issues are evolving in the global space. Thank you.
Okay, Paolo Bucci-Rossiler, the question is for everybody, actually. You all mentioned that you have introduced, or you already have, the power to review mergers that would be under thresholds, and we've heard yesterday that there is some concern from the business community that this might increase uncertainty because they don't know whether the merger will be asked, they would be asked to notify the merger even after a certain period of time. So I was wondering whether you have some experience in applying this rule already, and whether you have made any step, to improve certainty for the business community. If you have adopted any, self-restraint regulation or some methods to, guarantee that the merger will not be reviewed after a while.
I managed to press more of those buttons than I ought to have. So ours is a mandatory notification regime. So the entities who are who meet the threshold. At the moment, it is an asset threshold and it's a turnover threshold. They have to necessarily notify to the Commission. Similarly, when a deal value transaction threshold is put or is enacted and comes into place, then those entities which would meet that deal value threshold would necessarily and mandatorily have to come voluntarily to the Commission and notify. If they do not, if there's a gun jumping case, then yes, we have a method of examining cases and sending out a show cause notice to entities which may have gun jumped, which we may have got information from or so moto. But that also is restricted within the law. We cannot go back and ask questions on something which has happened more than a year back. So I think the regime in India is very careful about providing great certainty to businesses on these aspects. Thank you.
From South Africa, so this is, because we have had these discussions at the ICN, I think maybe 5 years ago. So how our law is structured is that there are set measures that require notification have to meet certain thresholds, but there's a residual in the law that says those that don't meet the threshold can be notified at the request of the authority. But we have 6 months to trigger that, right? So if you don't come within 6 months, then the measure can go ahead. What we have done is that we published what we called, they are called so-called small measures in South Africa. So those measures, we now have guidelines. So initially we had said, well, if a firm is facing, prosecuting a firm, it's a cartel or whichever way, they need to notify us if they are merging. The respondents want to merge. We have now added the transaction value threshold, which, as I've said, we've published these guidelines today. We had extensive consultations with stakeholders. What this means now is that in fact, we were debating whether we have to make that mandatory, but we are simply saying businesses should inform us. So if the value of the target meets the minimum threshold, the deal value meets the minimum of the threshold, and the acquirer meets the highest threshold. So we are targeting the sort of large firms acquiring startups and all. So they need to notify us, and then we can indicate whether they should file or not. So this is so the law permits us to do all of this in current form. I think it's for us really to give the guidance that we gave. Yeah, but I don't think it will raise, at least for South Africa, any cost. Of course, the notification places some costs, but we will only pick those that we think are significant.
And just to clarify, it's very interesting to hear from Harding. From the Brazilian perspective, actually this discretionary power exists in our legislation for the last 10 years. And we don't have any established guidelines on how to use this discretionary power. But I think that from CADI perspective, we understand this kind of concern from firms, and we are very restrictive in the use of this kind of power. And as occurs in the South Africa, we have also a deadline of 1 year to request the companies to notify the merger, and so but overall we are very restrictive in making this kind of requests.
Thank you. I think I will just ask for a final question because I think we are running out of time. I don't know if anybody in the audience still would like to take this opportunity. It does not appear to do so. Let me also just somehow reassure, between brackets, Paulo, that I think all of us in the international organizations, and I did not mention, of course, the ICN, which is also extremely active and whose action has been extremely important. are very mindful of the need of legal certainty and predictability for businesses. And I think we all recognize how important is guidance from competition authorities, which we all recommend. But it is true that we are going through, well, special times in a way, because if we consider that maybe until 5 years ago, I remember at least in Geneva in our group of experts meetings, we still then thought that, of course, competition authorities would be more concerned with not intervening in order not to stifle innovation. And in the meanwhile, trying to catch up with the very quick developments of the digital online marketplaces, we have seen competition authorities and governments either going through regulation. We have seen competition authorities being much more agile through enforcement, through the use of market studies, to the introduction of digital tools to identify, cartels and, like the Cerebro project in Brazil. So I think we will definitely can look forward to extra guidance when I think our colleagues from these jurisdictions, like in Europe, are comfortable enough to issue this guidance, and this will be helpful for businesses. But it is true that the digital market is still evolving, and I think everybody is more or less looking at each other's developments. Of course, the EU as such playing a very big part due to the implementation of the Digital Markets Act. On this note, I would like, first of all, to thank very much the speakers. Again, thank through Paulo the invitation, the opportunity, the fantastic welcome that I think all of us had, and thank you also to your team. All of them have been extremely nice and welcoming. And please join me in just congratulating our speakers for this discussion.